And you're doing this pro bono? I don't think she has much cash.
No.
What are you getting?
Well, Sarah's got to pay me back one day.
Okay. Okay.
That was the agreement I had. I wanted her to understand that she needs to be self-reliant and she needs to be responsible for fees. I've got a bunch of clients that are paying me, and some of them only pay $50 a month. And but it's important to me. It's important to them, that we have an arrangement to make payments, and that's what I told her.
Do you think?
I feel.
Do you think she needs to tell her story in the courtroom?
Well.
Back. Welcome. This is a highlight about James Owens and Sarah Boone. Was James banking on the alimony arrears for his payment? What exactly did he mean by Sarah's gonna pay? Yeah, she's gonna pay one day. We're gonna take a deep dive down some footage that I found, and it's pretty interesting. I think Sarah and James were plotting on the arrears. Leave a comment below and let me know what you think. Let's get this party started.
Sarah's a unique individual.
If she gets in your face, whatever she does, you do not have a right to hit a woman. No, sir. What has the state attorney tried to do?
Objection. Proper argument. Sustained.
What have they done?
Objection.
What evidence have they? What evidence?
She helps everybody. She's always, spirit. She helped me a lot, and she would come to me. She talked to me all the time and pick me up when I was down, or if I didn't know something. She's good. She was a good person to me. Mistakes happen. She always helped. She always helped people. She was always helping everybody in the dorm. Even like her artwork, she did art. If anybody needed any help or needed anything, they'd come to her and she'd help them. And even if they, did wrong to her, she would still go back and help them and praise with them and pray over them and everything. It's just.
And was she a little bit older than you?
Yeah.
How much older was she?
40 in her 40s. So, yeah.
Did you think of her as maybe an aunt or a big sister?
Big sister, yeah. She was like a big sister. Like a sister I never had.
Miss Hill? Judge.
From Lana to Sarah. Hey there's the subject. Who knew our lives were going to pick up like this? Wow. Where were we 3 months ago? You were dealing with bitch-ass Cashman and pretty much on your own. Now you have a team of Billy and James's team, and I'm along for the ride too. All of us with one common goal, and that's to set you free. And now we have a production company wanting to immortalize your story for people to bear witness and possibly save future women from getting mistreated. I know James is working hard. I'm pulling that. We get that. Wow. I'm pulling that we get that continuance, and it'll make people's lives so much easier all around. I emailed him everything you talked to me about, so I'm sure he is going to address it all. Just letting you know, I have lunch with a friend tomorrow, so I'll be available some of the day. If I don't answer, that's where I am. She's been trying to schedule with me for 3 months, and we've been back and forth with one of us not being able, so for whatever reason. So this is long overdue. Talk to you soon. I believe in you. And before Sarah can respond, Lana's back on it. She heard from James. She's excited. Hey, I don't know when James sleeps. He's a total night owl like me, which is outstanding. But then he can be up at 6 a.m. getting stuff done so he can operate with the court. I've read the state's objections. I mean, some of them are, these documents haven't been produced. Those will not take a substantial amount of time to address. Others of them are hearsay. The state's objections are poignant and direct. So I can't imagine it will take us more than an hour, maybe an hour and a half tops to weed through that. I have arrangements tomorrow. I don't know how any notices and waivers have been filed, and I have one reset plea. So let's plan on kicking off at 9 a.m. tomorrow morning. I'll advise them to be here at 10. And that way, we can bring them up at 10:30. They can report downstairs, and we can bring them up at 10:30. It gives us a little bit between an hour and 15 minutes. Mr. Henderson, it should give me enough time to get to my part. The court. All right, very good. All right, thank you. I'll give them the same instruction that I've given our panel the last couple of days as well, in open court. This part of the sidebar conversation kind of stuck out for me. You know, they've been floating around, and it's leaning towards the family court case, which is coming up. So I just want to touch on this. And this would be Judge Cranick, Mr. Owens, Mr. Henderson, and Mr. J. When I say the court, that represents Mr. Judge Cranick. I was going to call him Mr. Cranick like Sarah did when she disrespected him in that letter. I think she just called him Michael. Didn't she just say, Dear Michael Cranick? The court. I was on the family bench for 4.5 years. Here's my concern. I don't know the status of the litigation, but if there's a pending supplemental petition and he's arguing a substantial change in circumstances regarding alimony, there's not a requirement for him to pay it. It's not contemptuous. Sidebar. Brian is definitely arguing a substantial change in circumstances regarding the alimony due to his former wife and former mother of his child, Sarah Boone, who decided to, in the good old sunshine state of Florida, to horribly take the life of her mate. And now she wants to be taken care of by former husband, even though the state has provided everything she's needed to survive. She still wants former husband to chip in and keep her out of the negative. Mr. Owens, yeah, I don't think that's the case. I don't believe that's the case. The court. There's not a pending supplemental petition. How did he move to Gainesville? The only way he can do that is with a supplemental petition. Mr. Owens. The supplemental petition didn't have anything to do with alimony. It just had him. He wanted to move the child to Gainesville. And I don't know, the judge granted that order because he's living in Gainesville. So he got permission from the court. But I don't believe there was any pleading filed about staying his alimony payments while she was in jail. But I'll look at that file. Seems like good old James Owens is already trying to pull a fast one, but Judge Cranick served on the family law bench, so he's one step ahead of him. Mr. Owens, I think I would proffer that to the court if I was going to attempt to impeach him. The court. Mr. Owens. On a topic related to his family law matter, Sarah's family law matter. I would proffer that testimony outside of the presence of the jury for the court to make a ruling. The court. Okay. Mr. Owens. I don't know at this stage what he's going to say, but I think it is fair game on cross-examination to share that his bias against Sarah Boone, my client, Your Honor, he doesn't want Sarah Boone to have any contact with their son, Little Man. He says derogatory things to the son about Sarah Boone, and those are all fair game because he's fighting for full custody of the child, or wants full custody. Your Honor, he never wants Sarah. Well, he wants Sarah to spend the rest of her life in prison. This is Brian Boone. I think he's going to admit this on the stand, that he wants Sarah Boone to spend the rest of her life in prison, and he wants little man to have no contact with his natural mother. The court. Any response, Mr. J? Mr. J. I reviewed the family court file and I don't see anything contemptuous about what he is doing based on those court records, not based on my understanding of family law, which was taking a class in 1995. I do not want to put some caution into their sails. I believe it's going to be completely fair game for him to say, I'm choosing to take these actions because she's incarcerated. We've taken great steps to avoid them knowing that, besides the fact that she never comes in and out for jury selection. So I think it's fair game. I think it's going to be fair game for him to say, yeah, I'm not paying for child support because she's in jail. Yeah, I'm not paying alimony because she's in jail. And it's either been settled based on the court file in the family court case or it's still pending. I think that's fair. Yeah, I think that's fair. And then also there's going to be a prior consistent statement that he made to rebut this recent motivation for fabrication. So we'll be prepared to introduce those prior consistent statements as well. Mr. Owens responds, Judge, and I realize I may open the door about that type of testimony. The court. Have you had a conversation with your client about the ramifications of that? Mr. Owens. Of the jury knowing that she's in custody, in jail? The court. Yes. Have you informed your client of the ramifications of that? Mr. J. And also, Mr. Owens cuts Mr. J off. Tony Henderson and I have a 4-hour appointment with Miss Boone, of course. We haven't been able to talk to her much because of all this going on this week. But Tony Henderson and I are going to see her Saturday from 11 to 4 or 11 to 3. And then Sunday from 11 to 3. So we're going to spend time with Sarah Boone. What's that? 8 hours with that? This weekend alone. So we'll go over this as well with Sarah Boone. Mr. J. There will also now be tablet messages between Brian Boone and Sarah Boone that will become relevant if we go this route, and jail calls between the two of them. Mr. Owens. All right. Well, I just want to know the specifics. What exactly you all are utilizing, but the court. I think there's an if, then what happens? I mean, it's all going to be predicated on what he may say from a prior consistent statement respective. Mr. J. And there's a 5th DCA case, I believe, called State versus Williams that would suggest that we are not permitted by the court to be forced to tell people which particular pages we're going to introduce or which jail calls we're going to introduce, particularly when it's on rebuttal. This is all new to us that he was going to open all these cans of worms, but we're just cautioning him that there is potential rebuttal evidence on jail phone calls, tablets, and prior consistent statements, and the testimony that will come out that the reason he stopped paying child support and alimony was because of her incarceration, which continues. Sidebar. Now, this sidebar in particular is about Brian Boone testifying. They, which is Mr. Owens, are concerned that if Brian gets on the stand, that he will say, hey, I'm not paying her alimony because she's in jail right now and I don't have to take care of her. The state's taking care of her. I have to take care of our child, etc. And Mr. Owens doesn't want the jury to know that Sarah's incarcerated. And she has that right in America. Although, when she got on the stand, she ended up saying it anyway when they were talking about her weight. Remember, he said, how much do you weigh? You weigh 105 pounds? And she said, yeah, before I was in jail, or since I've been in jail, something like that. But Mr. J is just letting Mr. Owens know that, hey, if you put Brian Boone on the stand, I have the right to say what I want, bring up which calls, which messages from the tablet that I want, and I don't have to inform you and give you a heads up. Mr. Owens wants to know, like, what are you going to ask Brian? And Mr. J's like, I don't have to tell you. Mr. Owens, I think the state believes Brian Boone is a key witness. I think they anticipated calling him. We believe he's biased and has animus towards Sarah Boone, the court, okay? Specific statements that say may have been said. I just don't know at this point in time. So I think there's enough potentially there for some level of impeachment, maybe, and that may be enough. So I'm going to overrule your objection for now, but I am going to ask that before we proceed with anything from the family law case on cross-examination regarding Brian Boone, that you ask to approach so that we can have that proffer and really dial it down at the point in time, okay? Basically, don't push it. Mr. Owens, okay. And the TikTok number 35, Mr. Henderson. I'm sorry, Judge. I saw a TikTok. You know Sarah was away. Take a listen.
911, what is the location of your emergency?
4748 France Court, apartment 3.
4748, what's the street name?
France, Frantz.
And the apartment number?
3.
Is this a police or medical?
My boyfriend is dead.
Okay, send the line for the fire department. Do not hang up.
Fire rescue. What's the location, Mercy?
Desk 32.
No, please don't leave.
4748 France Lane, apartment 3.
France Court.
France Court.
Yes.
Okay, is this near Mackenzie Drive?
I don't know where that is.
Okay, fine, okay.
It's Hillwood Park Apartments.
Okay, 4748 France, correct?
Correct.
All right, correct. Now tell me exactly what happened there.
My boyfriend and I were playing last night, and I put him in his case when we were playing. And
Okay.
like kind of hide and seek kind of thing. So I fell asleep, and I woke up, and he was dead in the suitcase. So I don't know what happened. I don't know what happened.
Right, okay, what's the apartment number?
3.
I don't know.
Apartment 3?
Yes, like he has like blood coming out of his mouth, and I don't know if like he had like an aneurysm or what happened.
Right, okay, all right, okay. Listen, we're getting help out there too. All right, okay. Okay,
Now?
Okay, yeah, man, listen, we're on breastbone, right in center of the chest.
12, 13.
Grow up. Oh, please. Let me grow up. Oh, please.
You want to be a cop?
He told me like one time, like back before we got divorced, that at, I don't know, this bar thing over there across the street, near the Walgreens, whatever it's called.
Okay.
I've never been there. But somebody gave her a little bit of cocaine.
Please state your, raise your right hand now first, and go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections there.
And you're doing this pro bono? I don't think she has much cash.
No.
What are you getting?
Well, Sarah's got to pay me back one day.
Okay. Okay.
That was the agreement I had. I wanted her to understand that she needs to be self-reliant and she needs to be responsible for fees. I've got a bunch of clients that are paying me, and some of them only pay $50 a month. And but it's important to me. It's important to them, that we have an arrangement to make payments, and that's what I told her.
Okay, you'll be given a copy of the order that I just read from. Ms. Boone, you'll also be given a copy of the order. Do you have any questions for me?
I am thoroughly confused. Was a notice ever put online for this or mailed to anyone? I don't even know why Mr. Lane is here. I don't know why I'm here.
Well, ma'am, you are now representing yourself, and previously you had requested to appear at every hearing that was held. As you are now representing yourself, the court cannot have any hearings regarding your case without you being here. I put on the record and explained to you the process that the court has had with communications with the jail. I'm not allowed to look at any of that. I'm not allowed to copy any of that. So in speaking with the jail and understanding that you still have a private investigator that was provided to you through the state that's being compensated by the state, you're still allowed to utilize his services. The protections of the attorney-client privilege are still applicable to him, so he's able to review any of these documents, ensure that they are safely copied without violating any terms of the privileges. Those will then be placed on multiple USB drives and provided to you. Those USB drives will then be uploaded to a computer that has been secured for you at the jail for you to access all of that information.
Okay. My question is, was a notice of hearing posted or mailed to anyone to where apparently the news crews obviously got it? How is it that I do not know anything about this other than my bunk being kicked at 3 o'clock in the morning telling me I have court?
Ma'am, I have no other way to get in touch with you other than setting the hearing, which was set yesterday once I received confirmation from the jail as to the processes for how this would work. And I understand that your case is important, and I want to move as efficiently, as diligently as possible. I know that you've been waiting for this information, and it took some time to confirm the process with the jail. You've advised me that you have very limited space, you have almost no privacy, you have a small drawer where you can keep some personal effects. We could not send all of those boxes with you to the jail, and the jail advised me that they cannot take all those boxes. A process had to be created to make sure, and this is the process.
The process that I was explained after speaking to a couple of sergeants, and I've been waiting for that, and I would much rather prefer a hard copy of these to where I can write on them as opposed to anything that's on a laptop.
I am unable to provide that for you. I have been provided the process has been provided to me by the Orange County Jail. I understand that's your preference, but I can't do anything more than what I've done right now.
I understand. And I have had other information given to me, which is why I've been waiting for the boxes for them. So I don't know, is this something that I need to pursue continuously still for me to be able to receive my hard copies? Because no one tells me anything.
I cannot answer that question because that may call for me providing you legal advice, which I am prohibited from doing.
Okay. Well, because I have no other way of contacting you other than in a letter, and it's AKA worldwide. So am I supposed to go back and speak to the captain and whoever else it is that I might need to speak to in order to receive these?
Again, I cannot answer that question. All I can tell you is that we will have a hearing on August 5, whereby which Prison Break Investigations will provide all of the information on USB drives. Those will be provided to a representative from the Orange County Jail who will place all that information on a laptop for you to use, and that's accessible for your use from 0800 to 1600 every day.
Right. Okay, so I guess I will figure that out, because if I'm up at 2 o'clock in the morning, I can't utilize the laptop, which is why another reason why I was looking forward to the hard copies. So my other question is my time prorated for the time that I've been waiting for my discovery?
I'm not sure I understand what that means.
Will I be having additional time added, or will it be extended from the time period of me waiting for my discovery still?
I'm not in a position to answer that question. I don't know what it is that you're asking for.
My pretrial is supposedly set for September 24th, I believe it is. So obviously I will not be prepared, and obviously I do not know what I'm doing, and obviously I'm still waiting for my discovery. So for that time period that I have been waiting for almost 4 weeks now, will that be added to the time frame in order for me to be properly prepared?
As of right now, the dates are what the dates are, ma'am.
Okay, so I just miss a week, a month.
The dates are what the dates are.
So I also sent you, I believe, 5 motions. Have you received those?
No, ma'am, I have not.
They were mailed last week.
Then I have not received them yet. The last...
I don't think you have enough time. I'm just doing my best, and if you could please keep an eye out for my motions.
I will be on the lookout for them. You said there were 5, correct?
Yes.
I will be on...
If you could please include me on the certificate of service for whatever hearings that we have that are no longer a surprise for me, please.
Understood. You'll be given a copy of the court's order that I read momentarily, and I will see you both on August 5 at 8:45 in the morning. All right. Thank you all very much. Mr. Cacciatore, anything further, sir? That is all going to be yours. Yes, I would, sir, so that you can begin the digitization process. All right. I'll see you on the 5th. Perfect. Thank you, sir. Yes. I'm just...
Yes. Sir, can you just hang out for a second so I can give you a copy of the order? Appreciate you. Thank you.
Inquiries of you, ma'am, before release. Are you satisfied with your attorneys so far throughout this trial?
Definitely.
And are you on board with the strategy that they've employed so far in this trial?
Definitely.
All right. Thank you very much. We'll be in recess till 2 o'clock. Court's off the record.
Cool.
My boyfriend is dead. Come on, please, hurry up.
Okay, ma'am, they're driving here as fast as they can. Okay, don't stop to say hurry up. Just keep on pumping and counting.
I'm still doing it while I'm talking to you, okay?
Okay.
Still doing it.
All right, just continue pumping. Just count on a second count with you.
1, 2, 3, 4, 5, 6, 7, 8.
Okay. Keep pumping his chest for me, ma'am.
I'm still doing it, okay? Still doing it. Just don't make me count, okay?
Right, okay, that's fine. You're doing a good job. Just keep on doing it for me. That's all right. They're getting there as fast as they can, along with the sheriff's office also, okay?
Please.
Okay. Keep on pumping, ma'am. 1,
We were playing hide
2,
and seek.
3, 4. 1, 2, 3, 4. 1, 2, 3, 4. Keep on pumping for me, ma'am.
I'm doing it. I'm doing it. Believe me, I'm doing it, okay? We were playing hide and seek.
Okay. All right, I understand. All right, just keep on pumping for me, okay? Okay.
Please hurry. This
Right,
is
okay.
horrible. This is horrific. What happened? Like, what happened?
Okay, ma'am, just keep on pumping his chest for me, okay? They're in the parking lot. They should be up there shortly, okay?
Yes. I'm still doing it, okay?
All right, okay, good. And you found him in a suitcase, you said?
Yes. We were playing hide and seek last night. I fell asleep. I think they're here.
All right, just keep on pumping his chest until they take over, okay?
I am.
Okay.
I am.
Okay.
I am.
Okay.
Open. Come in. Can I stop pumping now?
be my investigator? Why can't I have my medical records? Why can't I fully utilize my constitutional rights? There's 3 pages worth of questions that I have.
What constitutional rights specifically?
I'm very leery about having a fair trial at this point. There's a handful of other...
What did you think of Sarah's Oscar-winning performance?
And you're doing this pro bono? I don't think she has much cash.
No.
What are you getting?
Well, Sarah's got to pay me back one day.
Okay. Okay.
That was the agreement I had. I wanted her to understand that she needs to be self-reliant and she needs to be responsible for fees. I've got a bunch of clients that are paying me, and some of them only pay $50 a month. And but it's important to me. It's important to them, that we have an arrangement to make payments, and that's what I told her.